Namaskar. In this episode of Dil Se, we'll talk about a recent controversy which is going to flare up very soon because Parliament is going to meet on the 21st of July, and the Minister of Parliamentary Affairs has said that the issue in relation to money found in a residential premises allotted to Justice Verma will be taken up on the first day. And he also said that there will be then an inquiry under the Judges Inquiry Act, and that should be completed within 3 months. This is the Minister of Parliamentary Affairs making this statement. So we're going to talk about this controversy, where it's going to lead us, what happened, what should have been done. All these issues will be discussed by us. But I just want to mention a couple of facts so that the viewers know certain basic facts. An incident happened on the 14th of March, around 11:30 at night, in the outhouse of the premises allotted to the judge. There was a fire in the outhouse which had one tube light and one fan working. That had happened around 11:30. The daughter informed the fire services. The fire services came, and between 12 o'clock on the morning of the 15th or 11:15 of 9 of that on 14th March, till 12:11, certain videos were recorded. So the last video recorded was at 12:11 on the 15th morning. The fire services and the Delhi police, which was called immediately, were there along with the CRPF till about 1:56 in the morning of the 15th of March. Those are the timelines. Between this time, no member of the household was informed either by the Fire Services Department or the CRPF or the Delhi police who were present there that cash had been found in the outhouse and that the fire officers doused that fire. None of the family members, neither the daughter nor the PS to the judge. 2 phone calls were made, one by the PS to the Chief Justice, who was away in Madhya Pradesh in a far-off location where he could not be contacted. But they somehow contacted him at 1:23 in the morning, and a phone call took place between the PS for 230 seconds, that's less than 4 minutes, and with the daughter for a longer period of time. And the judge returned at 5 in the evening, that is on the 15th of March, and he did not go to the outhouse. He went to the family to comfort his mother. And then the PS to the Chief Justice of the Delhi High Court came, and he, along with the judge, went to the outhouse, and they found no money there. Which means that between 2 in the morning on the 15th March, if there was money there, and the following evening, when the PS, along with the PS to the Chief Justice, along with Yashwant Verma went, there was no money. So if there was money, it must have been removed. Now, every house of every judge is covered by a CCTV camera. You cannot carry any cash into any part of the premises because it will be detected by the CCTV camera. It was found later that the CCTV camera was not working. And that CCTV camera is under the control of the CRPF, not under the control of the judge, because that is for the security of judges. That takes place every residential accommodation that the judge is allotted. No premises was not cordoned off. No part of the cash was taken. We don't know how much cash there was. There is no finding to that effect. Even one note was not seized. Had they seized a note, they would have found out which bank it came from, and they would have discovered. So the judge found out about this cash only on the 17th when the Chief Justice called him and told him that this was what was found and showed him the video. And on the 21st of March, the Chief Justice of India, the then Chief Justice Khanna, transferred him to Allahabad High Court and stopped and made an order that no judicial work should be allotted to him. These then are the basic facts which are necessary for the purposes of a discussion. But away from these facts, there is one constitutional issue, and I'll start with that in the discussion, and that is that 100 members of parliament belonging to the Lok Sabha or 50 members of parliament belonging to Rajya Sabha can move a motion for impeachment. Now, that motion has not yet been moved so far. And in the meantime, people in the government or ministers in the government are making statements. Chairman of the Rajya Sabha has also made statements to the effect. And in the meantime, the report has come suggesting that the judge was responsible, not that the cash belonged to him, but that it was placed in the outhouse with his tacit or active consent. We don't know what that means. But I have three extraordinary people with me today. Justice Madan Lokur, who was kind enough to come. And Justice Lokur today is an international personality in the sense that in 2024 December, you, sir, were appointed as chairman of the UN Internal Justice Council. Before that, you were a member of the Supreme Court of Fiji. And you've had a long, illustrious career. You've been a judge of the Supreme Court from 2012 to 2018, 6 long years. And you also have led the whole E-Committee movement in the Supreme Court, rendered about 150 judgments, very concerned about social causes, waste management, environment, and all that. So we'll seek your responses to this very, very soon. Justice Kaul, thank you very much for being here. Well, you belong to a family with a lineage of about 500 years. Your great-great-grandfather was the revenue minister in the Regency Council of Jammu and Kashmir. And your great-grandfather, was Daya Kishan Kaul, was Prime Minister of Kashmir. Your grandfather was right?
Is it Patiala?
Patiala, okay. So there it is. And you have been Chief Justice of the Punjab Haryana High Court, Chief Justice in Chennai in Tamil Nadu High Court, and of course a judge of the Supreme Court for several years, and you retired recently. You have been part of Puttaswamy's judgment, part of 370. You have actually been asking the executive, let's get the appointments process moving. So deeply, deeply involved in the judiciary. Thank you very much, sir, for being here. Justice Mukta Gupta, you, as I said, nobody has prosecuted matters of national importance as you have as a judge, as a prosecutor. For example, you've prosecuted Jessica Lal case, the Naina Sani case, the Nitish Katara case, the Red Fort attack, Parliament attack. All of them, you've been the prosecutor and got convictions. You've been handling the roster in the criminal bench with great admiration, I must say, of all the members of the bar. You've been a judge in that very high court in which Justice Verma was. Of course, it's wonderful to know that you did your BA in zoology from the college. I didn't know that. March from zoology to law is a great strive forward. Thank you very much. I want to ask you a constitutional question. Under the Constitution, 100 members of Parliament can move in Lok Sabha, 50 in Rajya Sabha. So this is a right given to members of Parliament. Government has not been given a right to move a motion for impeachment. So why should an in-house procedure of the Supreme Court send a report to the Prime Minister or the President of India when governments have no role to play in the impeachment motion? I want your thoughts on it.
Yeah, well, thank you, Kapil. I am as intrigued as you are about why the report of the in-house inquiry was sent to the Prime Minister or to the President. The in-house inquiry was called by the then Chief Justice of India. He wanted to know what had happened, right? And so the report was given. He appointed the members of the committee and they gave him a report. Now, having received the report, he had two options. One is to reject it and say that, well, I find nothing in this report. The second is to accept it and say that, some steps should be taken. Now, in the in-house inquiry report, what has been said is that, cash was found at the residence of the judge.
In the outhouse.
In the outhouse of the judge, and that steps should be taken for his removal. Now, obviously the Chief Justice of India accepted that report. Having accepted that report, what he should have done, in my view, is to have the Secretary General of the Supreme Court lodge an FIR. Okay. Again, there are two things. One is he could have said that you lodge an FIR against unknown persons.
Yes.
All right, and say that find out. Let the police find out.
Especially when the judge has said it doesn't belong to.
Yeah, the judge says, and the judge also says he didn't find any money over there. So against unknown persons, or if the Chief Justice of India felt that yes, it's the money belongs to the judge, or he's aware of it, or whatever, how he interprets the report, an FIR against the judge. Neither of these things was done. So I'm a little intrigued why it was sent to the Prime Minister and why it was sent to the President. Because it was a decision that should have been taken by the then Chief Justice of India to lodge an FIR, to get the matter properly investigated, right? To move an impeachment motion, there should be an investigation. Some report which says that, after investigation we found that the money belongs to this judge.
Yeah, but I understand that.
Yeah.
That's the process after he came to some conclusions.
Yes.
Right?
Yeah.
But I am asking a fundamental question. The moment you send the report to the government then naturally, when it comes from the Chief Justice of India, will move in the matter. Whereas the Constitution removes the government from the process.
Yeah.
So, in fact, in a sense, that process has got tainted by the government being informed and the government saying, if the Chief Justice of India has told us, we must move.
Yeah.
Right?
Yeah.
So this in-house procedure seems to not be consistent with the constitutional provision. What do you say, Justice?
Kapil, just one thing. By doing this, actually the process has been made political.
That's correct.
Which it is not.
Which it is not.
Yeah.
So, my first aspect I would say is, this is a very preliminary inquiry.
Yes.
By the time the report comes, the Chief Justice is on the annual of demitting office.
That's right.
And the judge is given some 2 hours to respond, 2-3 hours, whatever, to respond. So, couldn't have responded really. Now, as Justice Lokur said, there has to be there is no investigation into it. 2 sides probabilities are weighed. Some statements of police and fire department recorded, some statements of staff recorded. It is weighed by the committee in a way that, look, probability of this version being there is higher. And because some of the staff came from his home state, they would have an innate loyalty to him.
Right.
This is the background in which this is done. The only question is what to do after this report. As he said, a further investigation by the police was necessary. 0 FIR could have been registered. One of the biggest problems I think envisaged is that when the incident occurs, the judge was not there. So insofar as the outhouse is concerned, nothing was done to protect the premise of the outhouse also.
Right.
Now, were the notes, where did they go? What was
Not
the
a single
quantum of
note
the
recovered.
burnt notes, so-called notes, burnt notes? So only thing is the video, that video clip,
Right.
which shows some notes. And then the press went into hyperbole on figures and other things. Now, that being the position, somewhere the final report would have to be sent. The other is that report to the satisfaction of the Chief Justice has to be there. He having formed a satisfaction, it should have kicked off the further inquiry by the police. So today what is happening is, with the report being forwarded to the government, as you said, the government seems obliged to act on the report of the government, on the report of the Chief Justice, and move a motion for impeachment. And in that process, as we seem to get from the press reports, they are making moves with the opposition and others.
So, which is they are moving political parties when it's a non-political process. Is the point I'm making?
Yes, and I'm a little concerned by the fact that the endeavor should not be to make an example out of the judge without first finding him whether he's done something wrong or not.
Exactly.
There is an issue. There are judges and judges. There are judges who carry higher credibility. There are judges who may not carry that credibility. Here was a judge who carried a very high credibility. In my view, having come to Delhi, he established himself here, which is a very difficult task with the bar and the bench in Delhi. Having done that, the my inputs from the Delhi bar are they themselves don't believe the story as it is transpired, but somebody has to get to the truth of it.
True, true.
And for the truth, the investigation is necessary.
Correct.
Then only one could have said that what is the possibility of the judge being charged or what action should be taken. The focus is completely now shifted to the Parliament for the MPs to debate on the basis of this preliminary report.
Right.
And the forwarding by the Chief Justice, of course, causes, it causes a problem in this issue.
That's right. What do you say?
So my take is that when it's against a judge or a judicial officer, it not only affects the judge, his career, his life, his family, but it affects the other judges as also the faith of the people in the judicial system. And thus it is very necessary to have concrete and proper facts before anybody is indicted. Okay. Now this inquiry, the fact-finding inquiry, now we don't have the copy, but whatever is floating in the media, as I was reading it, it says that the secretary says it's an arson, the judge says it's a short circuit. But the fact is, whenever there is a fire, the fire department comes and the first report they give is what is the reason of fire. Unless you go to the basis of it, we've all lived in these houses, we know there is security at the front gate, but at the back side there are so many servant quarters with their families living. Back gates are not meant by CCTVs or by the CRPF and all. And there is a total ingress outgress over there. So to say that the judge exclusively had possession of the premises. Now when as per the report, inference has been drawn that since it was in his possession, so he has to explain it. Now we all know the law is, if it is only in exclusive possession, then that inference can be drawn. The moment they say that it was accessible to the family, the servants and all, so there are a number of people. And so it's so very important to have an in-depth, proper investigation into the matter, how the money reached there, if at all it was there, how the money reached there. Because that's the first step. Only subsequent acts or inferences would follow thereafter only.
Correct. So you talked about possession now, as I understand, and you are very familiar with this branch of the law. The burden of proof shifts only in one of these Prevention of Corruption Act cases, when you do a raid and you find money in somebody's drawer sitting in the office or somebody's hand, then the burden shifts. So but that test cannot be applied to a situation like this.
We've seen
cases, and the committee has applied that test.
We've seen cases where money has been left outside, or somebody has tried to, in those cases, the courts have held that the presumption the onus doesn't shift on him.
Correct.
You can't raise that presumption.
Yes, and this is what the committee has done.
This is what the committee has done.
But let me ask you, the point is the judge is already held guilty by the people of this country. Because you sent the report to the government, which you should not have done, even though it's part of the procedure. The judge would not have revealed the report to anybody. The Chief Justice of India would not have sent the report to anybody. Obviously, the report has come from some other quarters. It's in the public domain. It has been selectively debated on channels. Some say 15 crores were found, right? Not a single note has been recovered, alleged currency has been recovered. And the judge is held guilty. Now the whole process, according to me, has been contaminated. How do we then hold the judge guilty when the whole process is contaminated?
Yeah.
I mean,
you're right on that, I mean, everything has happened,
And without an investigation.
Without an investigation and without anybody knowing what is the truth.
Yes.
As Mukta says, where did the money come from? Yes. I mean, assuming money came.
Yes. No, money, we'll assume that the video reflects the true story.
Okay, fine. So where did it come from?
Yes.
And where did it go?
Yes.
And does anybody know whether they were genuine notes or whether they were counterfeit notes?
And how did it come? Apart from where? How did it come?
Yeah, how did it come? So, I mean, I think the entire episode raises more questions than provides answers. And for this reason, I think an investigation is absolutely necessary. Unfortunately, there is no investigation. So everybody's just guessing that this is what happened and this is what may have happened. Nobody knows what the truth is.
And on the 23rd, the following Sunday, I believe somebody finds some notes on the roadside.
Yeah.
That's the other thing.
But that person has never come forward.
No, he's not.
And
They have not-
nor have those notes come forward.
Not on the notes.
Not one single note is recovered.
Actually, he's been damned in the public opinion.
Yes.
This is the problem of the news methodology.
It's a
which we
miscarriage of
follow.
justice, according to me.
Everybody is talking, so one of the interviews earlier said that, look, how do you explain a room full of notes? I said, let us see, where is this room full of notes? In the video, I see a ledge at the end of the room. From the ledge, something is swept down. That are not the notes.
Right.
While sweeping it down below, you see some notes burning. The currency which we have, the maximum is 500 rupees.
Yes.
500 rupees, it's a 50,000 bundle.
Right.
If it's the larger bundle, which they say of 10 notes, it's 5 lakhs.
Yes.
So you need 20 of those bundles to make 1 crore. That's the figures.
Right.
Now, how many bags were there? What they say is the plastic bags. How many bags were there? How much notes could have been put there if there were notes there?
Correct.
See, all this has remained a mystery because, in my view, the biggest folly was not keeping the area protected.
Yes.
Especially when the judge was not there. So it's not that you are interfering with the judge's working or something. In his absence, something is found. Circumstances of fire are at best questionable. What has happened, how it has happened, because ostensibly there's nothing for a short circuit or arson or something to take place because absence of any a fan or a light, short circuit really should not have occurred. Now, all this happens when the judge is away. So if the story is to be believed, he went away on a holiday, he put things in some sack, put him in the end of the room, left the keys with everybody else and went away. And then a fire takes place. So, certainly the least which is required is a proper investigation. Unless that investigation takes place, how do you do it? And please understand, all of us who stayed in government houses, there are parts of premises I know we've never visited. The last one I stayed in was Akbar Road. It has 27 quarters. It has storage space. It has 4 huge garages next to it, which were there. And there are staffs who outlice the judges. There are some staff who stay there. Another judge comes, he says, so-and-so is staying there. Let him continue to stay there. Somebody else comes in. So, it is the premises open to very large number of people. And before you damn a judge like this, and a judge who has never shown any lack of credibility, the signal, as Mukta said, is caused immense damage to the judiciary and permitted a situation to be raised, look, when the appointment process is in the hand of the judiciary, this is what happens. That's what my greatest apprehension is. Because personally speaking, I have been judicially and otherwise pushing that.
Yeah, I know that.
There should be an appointment process which must take care of it. In fact, I went so as to say, let there be the law which was enacted. At least we will discuss what is happening and get the appointments through, which is a different subject matter altogether.
That's right.
But it also creates a problem in that sense.
The problem is that the institution is damaged.
Yes, certainly.
And if the institution is damaged, what's going to happen is, now the Chief Justice of India forwards a report. When he forwards a report and coming from the Chief Justice, there's enormous credibility that is attached to that report. Now, who is going to disbelieve the Chief Justice? And if he does it without an investigation, actually, it puts the institution in the dock.
It's also
Because he should have been, according to me, Khanna was one of the finest judges we've had, but should have been more careful before forwarding the report to the Prime Minister and the President, knowing full well that the government will get into the act. And in this, normally, in other jurisdictions, this would amount to complete miscarriage of justice.
So you have 2 Chief Justices and a judge. Their report based on probabilities. That gives, some kind of sanctity to it. And then the Chief Justice giving his imprimatur to it.
No, but what sanctity? They say, and you know the report, I think all of you know the report, they say that we are not concerned about how the Delhi police acted.
Yes.
They say in the report, this is not part of our remit.
Yes.
So what was their remit? To find out if the outhouse has cash, but that the video showed. So what was their remit then?
And then saying that, you see, since the outhouse form a part of the compound of the judge,
Therefore, he is responsible.
therefore he is responsible, and if I may say so, that he did not protest on his re-transfer to Allahabad.
Yeah.
Certainly an adverse inference. It's a parent court.
Yeah.
Given the scenario, which judge is going to protest in this scenario?
Absolutely, absolutely. You know, there's another thing he said. He came back on the evening, but instead of first going to the outhouse, he
Yeah.
went to his house.
Yeah.
And that's an inference against him because he knew there was cash there, therefore he didn't go to the outhouse.
Yeah.
What do you say, Gupta? You've been on the criminal side. Can you
So
imagine?
that's what I wanted to say, that it has lots of inferences, adverse inferences drawn, which are not based on facts. And that is why this matter needed a proper, probably an SIT or a high-powered investigating agency to find out the truth in the matter. Because sometimes one fact which is apparent, underlying there may be so many other facts. And in a case of circumstantial evidence, as we know, unless we have the complete chain, seeing one fact in isolation can make whole lot of difference. So the genesis has to be gone into, the genesis has to be found into, how it came, whose cash it is, who brought it, how the fire took place, and on a day when a judge has been there. And of course, if it is found, please indict, but then please complete the chain. Today, even if you go by impeachment, it is a judicial inquiry.
Exactly, it's not.
There will not be going to be an investigative process.
Exactly.
And this needs a proper scientific investigation.
Yeah.
Without that, again recording statement of some people and on basis of 2-3 issues, coming to the conclusion and reversing the burden is not the answer, which is in fact contrary to the law which has been established by this.
Let me put this to you, since you are really familiar with this aspect of the law. Anybody who brings cash, assume now that the CCTV is not working. Somebody has come to the house and transferred the cash. Let's assume it is 3 sacks, 4 sacks, or whatever. Somebody in the staff would have transferred the cash. The judge would not be carrying it on his shoulder. Right? Somebody would have transferred the cash. Everybody in the area would know that the cash has been transferred, what time it was transferred, what days it was transferred. Everybody would know.
Even taking out from that place to the outhouse.
Correct?
So the staff is there.
Exactly.
It is not that
There's a security guard at the
There's a
main
security
gate.
guard.
He will know.
He
he will
know.
know.
It's not a handbag which is
It's
being
not,
done.
exactly.
They're talking in terms of sacks.
Exactly.
3, 4, whatever.
Whatever.
3, 4 sacks, as you said. The judge is not going to be able to lift it and do it there.
Exactly.
Let us say somebody, there's nobody, no other staff was taken. It is at a very protected kind of a time this was done. Still, somebody has brought these sacks
Exactly.
and put them there.
Yeah.
Now, investigation, at least for that, would be required. That nobody knows from where this money has come from. Somebody would deliver it.
Exactly.
Let us assume against him that there is
Exactly,
delivery of money.
exactly.
Who has delivered the money? Then there are issues about that person also who would have delivered the money.
Absolutely.
These are all matters without investigation would be very difficult. I think.
Exactly. Well, this cannot be investigated by just making, recording statements of people.
Cannot be.
It cannot be. So therefore, you have recorded statements, come to a conclusion. The Chief Justice of India agrees with that conclusion, send this to the government, and the minister says that we'll impeach him. Well, what kind of process is this? Now, let me go to another issue. All of you have been judges. There are CCTV cameras. They've been in your premises. Who controls them? The CRPF. It's not under the control of the judge.
Certainly, we didn't control it.
You didn't control. None of you controlled. So the question arises, what happened to the CCTV camera? Who has investigated that?
Nobody. Nobody's investigating that.
The forensic report says that the hard disk doesn't contain anything.
Yeah.
So, when did it stop working?
Exactly.
Till what time was it working? When did it stop working?
And who complained?
And who complained and how did it stop working? What is the
Exactly.
cause of it?
Exactly. No, this is not the only camera. There are other cameras. Nothing was working.
Yeah.
So therefore, if the camera stopped working, whose responsibility? The security of the judge is the responsibility of the state. It's not the responsibility. In other words, there's been a breach of security of the judge.
Yeah. Yeah.
And who has investigated that?
So the investigation issue has been washed hands off, actually.
Yeah.
Some money is there, some money is found. You explain how this money is there. It is part of your premises. That's all that has happened. And the premise, right or wrong, the police from the day one washed it hands off
Yes.
the whole issue.
Yeah.
So they didn't get into the task. Now, could
Why?
we?
Do you know why they didn't get into the task? Do you have any idea?
Well, they seem to convey that because of Veeraswamy's judgment, they were of the view that they have to only inform the Chief Justice.
That's not true.
No.
This is I'm saying so on whatever information I have received and believed to be correct.
Well, what-
That this is what weighed with them, now rightly or wrongly.
Yeah, but like you said, a zero FIR could have been filed against an unknown person,
Yes.
right? And on that basis, I think the police should have first of all lodged an FIR saying that this is what has happened, this is the information that we've got, right? We don't know who's responsible for it. And let the law take its course, as they say.
Veeraswamy's judgment in, I think, para 160, if I'm not wrong, says that if you are going to proceed against the judge, in other words, if you want to
Name the judge.
then you have to get the sanction
Yeah, yeah.
of the Chief Justice of India, right? But at this point in time, you could not have named the judge because you haven't conducted an investigation. That will only happen after an investigation. So the Delhi police should have lodged an FIR
Against unknown persons.
against unknown person.
And at least from the point of view of the incident of fire.
Exactly.
In the secured
Yeah,
premises, a fire has taken place.
Yeah.
How the fire is caused itself is the first question on which the FIR should have been registered.
Absolutely.
Then if you had, assuming these are cash and others are there, you would at least protect the area. As I said, a cost of reputation, the judge is not there. So let's look at for something to be preserved for him to come and see what has happened in this premises.
And this, if one note had been recovered, Mukta, if one note had been recovered, we would have known what the source is.
From the numbers, you can then trace back from
To
where
the
it
bank,
came.
to the
Right,
bank.
right.
And then you can
And
find
if
out.
it's changed number of hands, it may be difficult, but when at least it was released from a particular bank,
Yes.
one can find out
Right.
from the number. And this basic investigation, if the money is there, whose money is there, how it came, is a must to come to that conclusion that money was actually there. I go to another extent. If it is, whether it was cash or it was fake currency, even if it was fake currency, it's again a serious matter. So the first thing which the police was to do was to cordon it off, to find out, to secure that place, to maintain the sanctity. Panchnama or secure that place immediately. If there is another incident in a judge's house, supposing, say some bodily injury, will they not enter? They will still enter. They will still act.
Or they will inform the family.
They will immediately act.
So this is an entire mystery. Now, what should be done?
I think it should be referred to Sherlock Holmes. No, but seriously, I think there has to be an investigation. None of us are of the opinion that there should not be an investigation. There has to be an investigation. There should have been an FIR filed, and the Delhi police should have investigated. Now look at this report. Apart from the discrepancies in the report, the chairman of the Rajya Sabha has gone on record to say that this has no legal sanctity.
Right.
Now, Parliament, Lok Sabha or the Rajya Sabha MPs are going to act on the basis of a document which the chairman of the Rajya Sabha says has no legal sanctity. What do you make of this? Are you going to have 100 MPs from Lok Sabha signing an impeachment motion on the basis of a document that has no legal sanctity?
But it has no legal sanctity.
Yeah, but then why? How and why should the MPs proceed?
That's the point.
This is the only basis on which it is being proceeded
Exactly, and which has no legal sanctity because there is no investigation. 124(5) requires an investigation.
Yeah,
In
absolutely.
the absence of an investigation, how can this report have any sanctity at all?
Even now, son, when the investigation has to take place, of course, it's a challenging task. He rightly said of Sherlock Holmes, because you did not protect the area. If there were currency, that is gone. Whatever was seen in the video is gone. Everything is cleaned up. So it's not an easy task now to do that, but still,
you're dealing with an
investigation does
institution.
happen. Investigation does happen in such situation also.
Sanjay, you're dealing with an institution,
Yes.
not dealing with a judge, whether it's easy or not easy. You can't damn the institution and by prosecuting a judge like this and by removing him like that.
And once you do an investigation, one will find out at least some of the things I think can be located, even if the material is not
Exactly,
there.
because I believe if actually the judge is responsible, then he should be
Yes,
prosecuted.
certainly.
There is no issue on that.
Yeah.
But the question is, you can't hold him responsible on the basis of this kind of evidence.
My own worry is not the one single individual. Of course, it's a problem he is facing, but also the institution.
Come on.
You know, in a sense, you have not damned the judge, you have also damned the institution
Absolutely.
as a larger.
And that's where I think Chief Justice Khanna went wrong by forwarding the report, according to me. He should not have, because it would not have been made public. There would have been an FIR. The report would not be in the public domain. There would be no public debate. The public would not have come to any predetermined conclusion. The judge would not have been damned, and we would have had an investigation, and then everything could have moved forward. So there, I think there was, I mean, with great respect to him, there was an error committed.
Yeah, you see also, who made the report public, by the way?
This is another very serious issue.
You know, I mean, I am sure that the Chief Justice would have given it in confidence
Absolutely.
to the Prime Minister and to the President.
Yes.
So who made it public? And why?
That's another.
You know, that's the chilling aspect, Sanjay, that you are mentioning.
That's a fuel for the media, in a sense.
Yes.
That look, this is what has happened. Now, they can keep on debating on the basis of a report or damning him on the basis of a report without realizing the legal nuances of it, absence of investigation, how it should be done. Well, 3 judges committee have said this. So they will say this is what it is, and this is the final truth, and now please impeach the judge. So these, and the whole thing affects the institution. Public confidence, very important part of our system. If you talk to people, and we do talk to people now because we are out of the offices which we've held, they will all talk on the basis of these loose debates which have taken place. It will not be based on nuanced position of law which exists before you do so. So it's a very, it can be very dangerous actually.
No, it is very dangerous because, you know, any premises, anything can be put in any premises. At any point in time, today it's money, tomorrow it's, you know, it's some drug. Anything can happen.
Yeah, judge goes on a holiday or something and
some drug
comes
is-
back and finds there drugs in his house.
Exactly. Then what is to be done?
So these CCTVs at some stage, if I'm aware correctly, in the High Court, and I was part of this institution, Delhi High Court, were installed with this basis to safeguard the peripheral areas and other areas, so that one knows how the access is taking place. And normally when a person comes, there is an entry register. They record who is coming in.
Right.
Even if it's a known person, they will record and stop. In fact, they often stop the known people.
Yes,
in
yes,
any
of
case,
course, I know
and
that.
they'll say, "Okay, should we permit him inside or not?" They'll still record it.
Exactly.
I'm sure you've stayed in the same scenario prevails in a judge's house and the minister's house.
I was a little more, as a politician, we cannot probably stop people. We'll lose the next election if we do. That's another one. Let me come to a more nuanced issue. The police and the fire services people were there from around 12 o'clock till 1:56 a.m., 15th morning. Now, I'll assume that the cash was there, right? The last video taken is at 12:11. So between 12:11 and 2 o'clock, they were there. That's established fact. Cash could have vanished during that time. So they may have themselves taken it. I'm just, since we are going on assumptions, it's possible. Or after 2 o'clock in the morning of the 15th, between 2 and the next morning, somebody could have removed it, right? Now, there is no evidence, even in the report, of cash being found and removed at any time the next day. Nothing.
See, that
So
is
there is no evidence of removal. There is no video between 12, 11, 2 o'clock. That means at 2 o'clock, they could have had a video saying cash is still there. There is no video between 12, 11 and 2. They could have removed it themselves. It's possible.
It's possible.
Some other may have removed it. So as a judge who has been dealing with all this, given these facts, what do you say?
That's why it's very important to police to document each thing,
Yeah.
minute by minute. You can't make today, even with the change in the law by the BNSS, it says complete videography. You can't have selected videography. You need to have a complete videography which is immediately uploaded so that you know minute by minute what happened, how you left the scene of crime. Now, since neither it is documented by paper nor by way of videography, it is a very difficult task to now ascertain, if at all it was there, where it has gone. Who's the one? Because we always see in criminal matters that this is a gap of 2 hours when these people were present. It's a gap of another 2 hours when these people were present, and you've not been able to ascertain who is the one responsible for it.
Because any number of people which are unknown to the family, apparently, were present at that time between 12 and 2 o'clock.
And remember, the CCTV cameras were not working.
Were not working.
Yeah.
But the CCTV camera would not show because this is the outhouse.
No, but
then once they go out, what time they are gone,
that would be.
that-
once they go out and once the money goes out,
That also.
that also would come.
The staff would know.
Yeah.
But one big problem in these houses is the CCTV camera would be there on the main gate.
It's not in the other.
It's not on the rear gate.
That's correct. That is
So as I
correct.
said, there are tens
Okay.
of quarters.
Yeah, so it could
The
have gone
staff
from
is
there.
there.
Yeah, anything could have happened.
And staff, each one having a family of 2, 3, 4 people living in single or double quarters, whatever they are. So there are lot number. In the main house, you will find 2, 3, 4 people living, but in the outhouse and that, there are not less than 20, 25 people at any
Anybody
point.
could have taken it. And if the police had been vigilant, they could have seized that
Seized
cash.
that.
See, these are the other very, very, very difficult issues.
Not based on undisputed facts. One is a scenario of interpretation.
Correct.
On the conduct of the person on undisputed facts.
Right,
Somebody may say, look, this doesn't behove the judge. Somebody say, no, it's not such a serious matter. Here, the very fundamental issue is that those principal facts are disputed. And the material which could give rise to those facts has vanished.
Exactly.
This is the ground level problem in a matter like this as compared to some of the other episodes we have seen in the past.
Take Shekhar Yadav. Well, let's not go into others. Take Shekhar Yadav. Undisputed speech. Undisputed speech. Whatever he said is undisputed in the premises of the Allahabad High Court. Motion filed. I have signed that motion myself on December 13, 2024, where in July 2025, the verification of signatures has not taken place. The chairman of the Rajya Sabha tells me that my signature is not verified. When on 13th of December, I presented the motion to him in his chamber. I presented the motion along with 3 or 4 of my colleagues. And the Secretary General came and signed and the date of receipt of that motion. And I am told that I have not verified my signature. I mean, on the one hand, Kiran Rijiju says, who's Parliamentary Affairs Minister, that we will move this motion on the 21st and we must complete the inquiry within 3 months because we cannot afford, when it's the case of corruption of a judge, we cannot afford to delay the inquiry. And in the other case of Shekhar Yadav, you have not verified the signatures for 6 months.
And
Now,
that's a case of hate speech.
That's a case of hate speech, undisputed, where the in-house process was started, stopped by the Chief Justice at the instance of the then Chief Justice, Justice Khanna. Right? What do you make of this? How does a government have two different Mapdand, as they say in Hindi, to deal with these issues.
See, this committee in 3 months, which you are mentioning,
Yeah.
in the absence of investigation, what is the material on the basis of which they can form? They are disputed facts.
Yeah.
The report is based on probabilities,
Yeah.
simply forwarded by the Chief Justice, because
That can't be
within-
looked
within-
at. According to me, that can't be
I said
looked at.
within a couple of hours, the judge did not respond.
Yeah.
So for even the committee which will be formed, obviously there has been some debate whether this committee could be that committee, and certainly can't be, to
It
my
can't,
mind.
possibly.
Now, for the committee to form an opinion,
Because you have to have a sitting Supreme Court judge. In that,
Yeah.
under the Judges
Yeah.
Inquiry Act, you have to have a sitting Supreme Court judge and a person from the eminent jurist, plus another Chief Justice. So this can't be that committee anyway.
so how will that committee, I'm wondering aloud, how will the committee form an opinion if the fundamental of an investigation is not taken place? If an investigation report is there, they will look at the investigation report, say, this is the investigation report, it forms material for it.
right.
That investigation has not taken place.
Exactly.
If this committee's report cannot be looked in for purposes of that committee, then what will be the basis? Because these are not undisputed facts, as I said. It's not the view formed on it. So, let's say the example you gave of hate speech. Somebody may form a view whether it is hate speech or
Yes,
not.
exactly.
The admitted position that the speech is there.
Correct.
Here, that fundamental is missing.
That's
the
correct.
problem.
Now, let me ask you another very interesting question apropos this. Forget about the committee. What will the motion say? If you can't rely upon this report, how will 100 members or 50 members move the motion?
Yeah, yeah.
What is the evidence?
Yeah. On what basis?
On what basis do you move the motion if you can't rely upon the report?
Yeah, the Constitution requires an investigation.
Exactly.
And there is no investigation.
Yeah.
So what is the impeachment motion going to say?
Exactly. It can't say anything.
Can't say anything.
On press reports, we believe something.
How can you say that?
Or on the basis
just
of...
saying.
How can 100 members of parliament or 50 members of parliament say something like that? As atrocious as this?
And say something on the basis of a document which has no legal sanctity.
Exactly.
Not even press reports.
And why should government be taken two different postures
Yeah, yeah.
in matters of this nature? That also shows that the
That's
government
very
seems to be
selective.
very keen to actually deal with Yashwant Verma, Justice Yashwant Verma.
Yeah.
And why that alacrity, I don't know.
Yeah. No action taken in the other
In
case.
the other case.
And this one, you're in a hurry.
And there were reports in previous cases also. This is the other thing that I want to ask, since you've both been Supreme Court judges. Now, in the case of an in-house procedure, when you find that the judge has committed no wrong, right, that report is never revealed to anybody.
Yeah.
How does the public know?
So it's put a quietus too, since in the in-house there is a satisfaction that there is, it may be one report, it may be informal inquiry, it may be other things. If it is not to culminate into anything affecting the judge in terms of an adverse report against him, it's closed. The file
Closed,
is
because you
closed.
want to protect the institution.
Yes.
Right? You have the case of Justice Gogoi, you've had other cases also, where they found that no, there's nothing in it. That is to protect the institution. So fundamentally, before you proceed against a judge, you must ensure that the evidence is such that
Sterling quality.
it is of sterling quality, uncontroverted, that it requires a proceeding which members of parliament will decide, not the government.
Yeah.
Right?
Yeah.
That is the fundamental basis to protect the institution. Here, the institution is unprotected.
Yeah. Yeah. You see, I think the leakage of the report, the in-house inquiry is called by the Chief Justice, like I said earlier,
Yes.
for him to know what has happened,
Yes.
And therefore the Chief Justice should take a decision on that in-house inquiry. But then to send it to, the Prime Minister or the President, first of all, I don't know why it was done. Second, why
No,
was
the
it
procedure
leaked?
says so.
What?
The in-house procedure says
Huh.
that if you find the judge guilty, prima facie, you send a copy of the report to the President and the Prime Minister.
For what?
You have to do something. You have to tell me.
What will the government do on it?
Yeah,
If
how
the
can-
motion of the only method so far recognized is a method of impeachment,
Yes,
or in couple of cases where judges resigned of his own,
yeah.
or he's been persuaded to resign
Absolutely.
and done so, or in case of an additional judge, which we are aware of from Delhi, he was asked to resign. He had a second thought, but he had resigned by then.
Right.
So the resignation is accepted. So these have been similar examples which are there.
But what has government got to do with it?
So this is normally done within the fold of the judiciary.
That's right.
Before that.
That's right. It should be an internal report, and it should be kept internal till the facts are uncontroverted. This is the point I'm making. The moment you have sent it to the government, you have moved away from the constitutional process. This is a very serious issue and something wrong with the in-house procedure itself.
See, even in an in-house procedure, when it's said to be a fact-finding inquiry where there will be no cross-examination,
Yes.
the witnesses will not be examined in front of you. If that committee finds that there are certain material which need proper investigation, I think a part investigation or association of the investigating agency can always be opted for it to have a proper fact-finding report also, because that fact-finding report is the basis then how the Chief Justice moves
So the
forward.
problem is these in-house procedures don't allow cross-examination. So even an LDC or a UDC
In a
which has-
departmental
departmental
inquiry
is given more rights than a judge.
Judge.
And then that report is then made the basis of an impeachment. I mean, it's unthinkable according to me.
So this report could have even recommended investigation
Yes.
by the, as what we are saying now, thinking aloud.
Exactly.
It could have recommended that investigation. Then formation of opinion. Now, if on the basis of that report, the Chief Justice says this judge must resign or face the consequences within a couple of hours, maybe I can only think aloud that maybe the change of regime taking place at the helm of the judiciary pushed everything so quickly that
No, because he was retiring, in a few days.
and possibly wanted to wind up the thing himself. But ultimately, at the receiving end is the judge and the judicial system.
The institution is at the
Institution.
receiving end. Okay, now we've discussed all that. Now let's go to the fundamental issue. What now? Is it possible for the present Chief Justice now, let's say now, because according to me, this investigation, given the conduct of the Delhi police, should not be investigated by the Delhi, even if there's an investigation, right? Because it's an institutional matter. So any investigation done in the context of a judge for being impeached must be done by an SIT set up by the Supreme Court itself of officers that it chooses, so that you have a fair investigation, right, on which there can be no doubt. Can the Chief Justice today set up an SIT, have the Secretary General file an FIR, right, and get this thing sorted out before any impeachment motion is moved?
Well, that's an interesting question, but I think the Chief Justice can get the Secretary General of the Supreme Court to file an FIR,
It can
right?
easily.
The underlying assumption in all this is an issue of corruption.
Yes.
So if it's an issue of corruption, normally the CBI would come into the picture,
Yes.
right? So an FIR is filed, the matter is referred to the CBI. I don't know whether the Chief Justice can say that, listen, set up an SIT.
He could. It's happened before.
Yeah, maybe he can,
Yes.
It's
It's happened before. I mean, the Chief Justice's powers, because you're dealing with a member of the higher judiciary.
Yeah,
not dealing
yeah.
with it. So therefore,
But I think first it would perhaps have to go to the CBI and then maybe...
he may pick up officers from the CBI.
Yeah, as an SIT.
Yeah, it's possible.
Yeah,
it's
that's
possible.
possible, yeah.
What I'm saying is that to put a quietus
Yes.
to the kind of damage that it has done to the institution, I think we still have some window of opportunity of a procedure to be followed,
Yes.
which gives some credibility.
Yeah.
What do you say?
I would say, on the first aspect of the police, sometimes the police thinks judge's house, this wash their hands off and tell the Chief Justice. It's possible that could have happened. Now as the situation arises, Madan is right that it may go to the CBI, but I would not be very comfortable with it, is all I'm saying.
Yeah.
So possibly setting up of SIT in some form looking to the aspect that it's a judge's case, that some preliminary report is there, that material is not there, so it needs a deeper probe.
That's correct.
And some methodologies of trying to find out things. How is for the an expert in the investigation to be able to do. That may put at least give material, even if the parliament, ultimately the parliamentarians want to debate it out in the committee, or the committee to be formed. If this action is done first,
Yes.
then you
will
will have
stall that
some
process.
You will know what has happened.
Exactly.
Actually.
I mean, because even I know these procedures. This impeachment is a political process. Impeachment otherwise is a process through which each member is not governed by the whip, because he acts as a judge when sitting in parliament.
Yeah.
Right? Once the Minister of Parliamentary Affairs has made that statement, that becomes irrelevant. So you've already actually muddied the waters and polluted the process, because the government has got into the act. So the only way to actually do justice in the case is to move
Have an
forward.
SIT, as
What do
I
you
said
say?
earlier.
What do you say?
SIT itself, I said that it should be an SIT. You see, NHRC gets complaints of human rights violation.
Yes.
They have a retired DG as a member. They constitute special SITs committees, which is not regular police, not regular CBI, and they have the powers of investigation. So those powers can always be conferred on special distinguished officers who will investigate it properly, submit a report, and thereafter, of course, if it is found, action should be taken, because that is what will give credibility to the institution.
I think that seems to be a possible way forward.
Also that the institution has taken its call to take it to the logical conclusion.
That's right, that's right.
So
Don't
out of
leave it
this-
to the politicians.
Out of this process is also the importance of this aspect,
Yes.
that they've taken it further
Right,
to
right.
get to the bottom of the matter.
Bottom of the matter. I think we're all agreed on that. Let's hope that something comes out of it. But thank you very much for
Yeah, thank
all
you.
of you being
Thank-
here.
Thank you.
Thank you.